I'm going to be talking about, as Ian said, the kind of macro legal framework for AI. And I've tried to distill this down to the top 10 legal issues I think you need to know right now about AI. I am a technology and data lawyer. I've been doing this for over 20 years. I've seen quite a lot of innovation in my time. I started in the dot-com boom. That was a very interesting time, and then moved on to Web 2.0, for those of you that remember that. And then the social media revolution. Now we're into the AI revolution. So we're going to have a quick canter through these top 10 legal issues I think you need to know about AI. So firstly, AI is regulated. There's a lot of talk at the moment around regulating AI, which kind of misses the point that is actually regulated now. There are legal rules that apply to the use of AI. In particular, the GDPR. So a lot of what we're going to talk about relates to the GDPR tonight. Also the Equalities Act. And there's a number of other sort of general legal principles that apply to the use of AI. But there is more regulation coming. Not very quickly. The EU is currently looking at regulating AI. It probably won't finish finalizing that text until the end of the year, possibly early next year. And this has been, they've been talking about regulating AI for since 2020. So it's a slow time coming. And it won't be enforced until 2026. And what that will do is really categorize AI in a risk framework. So you'll have unacceptable AI, which will be prohibited, and then high-risk AI, which is where a lot of the focus will be. That's on things like credit scoring, loan applications, etc. The UK and the US at the moment have quite a similar approach. So they're taking non-statutory, i.e. they're not going to put anything specifically in law to regulate AI. It's very much principle-based. But the UK may legislate this autumn to require UK regulators to reflect the UK principles into the regulator's approach to enforcement. So the FCA, for example, that regulates a lot of financial services and fintechs. It will potentially be required to look at these principles, which we're going to talk about in number 2. Hopefully you can see that. And then when it approaches its regulatory enforcement duties and its powers and how it enforces financial services regulations, it will be required to take into account some of these principles. So what are those principles? A very high level at the moment in terms of safety, security, robustness, appropriate transparency and explainability. That's actually already an existing requirement under the GDPR. Fairness in terms of the outputs, accountability, governance, contestability and redress. So making sure that there is appropriate mechanism for users to challenge decisions based on AI if they need to. Okay, number 3, transparency for use of personal information and AI is legally required. And that's a fundamental concept in the GDPR and a fundamental concept in lots of privacy legislation around the world. So what does that mean? That means that you have to explain to people what information you collect, how you use it, and in terms of AI, ultimately how the AI works. So that is typically something that you would put in your privacy notice. And within your privacy notice, you would also need to describe how you allow individuals to ultimately exercise their rights, particularly around contestability. And that's important. Transparency is important because it's a legal obligation, but it's also a way of building trust with customers. But the key thing, if you're going to be transparent, is it needs to be accurate, because you're going to undermine, not only will you kind of breach legal principles, but you're going to undermine a consumer's trust if ultimately what you're describing is not accurate. So number 4, using AI in relation to automated decisions is restricted. So what type of AI are we talking about? Things like credit scoring, where you're using maybe AI to filter job applications in relation to serving customers different pricing, so price discrimination, fraud prevention, whether you're going to grant them loans or not. Those are all types of applications of AI that have a legal effect or a significant impact on an individual. So those types of effects and significant impacts are regulated. What that essentially means is you can't use AI that has that impact unless you've got someone's consent, unless it's necessary for a contract or it's authorized by law. So an example of something being authorized by law would be in relation to fraud prevention. But where it's not authorized by law, it's not necessary for an agreement that you have with an individual, then you need someone's consent. And what is also required, if you're using AI in that way, is that you need to implement some safeguards. And that essentially means having some mechanism for human review and also the ability for an individual to contest a decision. So, for example, if you've refused a loan application for someone and it's been taken by automated means, then ultimately that individual should have a right to challenge that decision and make representations. So data security, Ian mentioned that. That's obviously with AI, that can involve the ingestion of huge data sets. And that only increases in a multi-vendor environment. That's really where cyber hackers live. Pretty much every data breach that I've been involved in, it tends to be a vendor. So it doesn't happen within the customer's environment, it happens on the vendor environment. So where you've got huge data sets, a multi-vendor environment, that increases the risk of a data breach or some sort of cyber event. And there's one thing that I tell clients, it's don't lose data. I mean, one, it's a legal obligation, but only bad things come from losing data. Under the GDPR, you would have to notify a regulator. If you're regulated by the FCA, you'd have to notify them. You have to notify customers. Pretty much every single data breach that I've been involved in where a company has had to notify its customers, cue a flurry of compensation claims. People are very kind of savvy these days in finding low-cost, high-volume lawyers to go out and seek compensation claims from companies. So only bad things come from losing data. So that is something that if there's one thing you do where you're processing huge data sets, it's to keep the data secure. What does that mean in terms of minimum legal standards? It's encryption, it's anonymization. Those are the absolute minimum you should be doing from not only from an industry standpoint, but also from a legal perspective. You need a lawful basis to use data. What does that mean? It means that you can't just use data because it's publicly available. Now, there are 6 lawful bases. I'm not going to go into them. One of them is consent, for example. So if you have someone's consent to use their data, you can do it. There are 5 others. But what I think is very important to realize is just because the data is freely available or just because you can access it, it doesn't mean that you can use it. You can't use it to create a database. You can't use it to train your algorithms. And Clearview found this out very, very recently. They created a database of more than 20 billion images for its AI tech. It got fined 7.5 million by the UK regulator. It got fined 20 million by the EU. Also happened to Cambridge Analytica a number of years ago. I think in their case, the sanction was even worse in that they spent hundreds of man hours building a database that ultimately for them had a significant amount of value, and they were told to delete that database. So if your business is based on data, having the right legal foundations to use that data is not only important from a regulatory perspective, it's important if you're looking to raise finance or ultimately you're looking to exit at some point, because that will go to the value of your business. Consider in the context of training algorithms that maybe using synthetic data. I'm seeing that a lot in the health tech space at the moment because of the sensitive nature of that data. So I think synthetic data can be a privacy-friendly non-regulated way in using data to train algorithms. So that, I think we're going to see more and more of that over the next few years in terms of trying to use synthetic data. If you're not sure, ask a lawyer. Ownership, IP ownership and AI-generated works. Only a person can own IP. AI is obviously not a person. So there's a question mark who owns computer-generated works. According to the law at the moment, it's the person making the arrangements. It's not really clear what that means. Who is the person making the arrangements? Is it the individual creating inputs using AI? Or is it the developer that created the AI in the first place, or put it on the market, or is operating the platform that hosts the AI? That's going to become more of an issue, I think, if we move to more of an open source model in terms of AI. It's interesting to see what OpenAI is doing. And according to their user terms, the user owns both the inputs and the outputs, but that's subject to some important considerations. So is the input and the output, is it sufficiently original? So for any work to attract copyright protection, it needs to be original. And that's problematic, I think, where you've got a number of users generating the same inputs and ultimately generating the same outputs. So if multiple users are generating the same outputs, then that's not going to be sufficiently original. There's also an issue with existing IP. So with ChatGPT, that's pulling data from lots of different sources. Some of that sources and some of those sources of data and those content will belong to owners, and they will retain rights in that work. So number 8, so related AI and IP infringement. So a lot of AI uses large-scale data sets and also content for things like machine learning, and also generative AI in terms of ChatGPT. Now, where you're using large data sets and you're using content, and that content belongs to a third party, any use of that content is going to infringe their rights if you haven't got their permission. So even if you're kind of web scraping to create another data set from that content, that original scraping of that content will be IP infringement. So unless you're getting the permission of the owner to do that, that is going to be IP infringement. And that's why we're starting to see and some litigation in this area. So we've got Getty Images. I mean, they've always been very aggressive in terms of enforcing their rights. They're currently pursuing an action against Stability AI in the UK. OpenAI is being sued in the US with a number of authors where their work is being used as part of their service. The UK was kind of looking at this in terms of trying to create that pro-innovation environment for AI that Rishi Sunak and the government have been talking about. And they were looking at having an exception to copyright laws for things like web scraping and data mining. Unfortunately, they seem to kind of rode back on that, which is, I think, a little bit unfortunate, because the issues with web scraping have been problematic for a number of years, and it's only going to get worse, as we wish to use more and more data to train algorithms and also provide some of these services that we're seeing at the moment. The legal risk in terms of discrimination and bias is been very well kind of documented in terms of AI. I think what's important to note is that discrimination is unlawful on the grounds of certain protected characteristics, so things like sex, race, age, and disability. So if ultimately AI is being used to make decisions, and those decisions are potentially discriminatory, that is going to be unlawful, and I think Uber found that to their detriment when some of their facial recognition technology and their fraud detection technology has caused them to make poor decisions in terms of their employees, and ultimately they've been sued and lost. The way to mitigate that is really around implementing a robust governance program and thinking about issues around kind of data ethics, so ethical use of data, and ultimately having safeguards in place where there is some human intervention in terms of any decision and ultimately a right to contest. Lastly, compliance by design and default. So really think about building compliance into products at the earliest stage. I think that's super important. It's something that is a legal requirement in terms of the GDPR, privacy by design and by default. But it used to be the case that ultimately people would build tech, and if something went wrong, they'd ask for forgiveness. I think that's a flawed strategy now, and particularly in relation to AI. And a lot of companies have found that out to their peril. So I think at the very early stage, when you're building products and services, I think it's really important to try and build compliance and ethical use into that product. As I say, it's very much something that's required by the GDPR. So the key things are things like data minimization. So what is the minimum viable amount of data you need to make your product and service viable? Make sure it has privacy-friendly settings. Well, what does that mean? That you don't have things like location data turned on, that ultimately users have to opt into that. And in fact, any kind of further information you want from users beyond that minimum level of information, that should always be subject to some form of opt-in. And ultimately making sure users have control of their data. So that's a whistle-stop tour of the top 10 legal issues. Happy to answer any questions.